Hello, my name is Shelley O'Neill and I'm the Chief Judge of the Reno Municipal Court. This is the time and place set for your initial arraignment hearing. All charges before this court are misdemeanors. This arraignment hearing has three purposes. First, to inform you of the charge or charges against you. Second, to inform you of your constitutional rights. And third, to give you the opportunity to enter a plea. A misdemeanor charge carries a maximum fine of $1,000 and/or up to 6 months in jail and/or 200 hours of community service. These are your constitutional rights. You have the right to be represented by an attorney at all stages of the court proceedings. If you cannot afford your own attorney and you are facing potential jail time, a court-appointed attorney will be assigned to represent you at your trial. You will be required to fill out an application containing financial information to determine your eligibility. The court will review the application, and if you meet the qualification, you will be entitled to be represented by a court-appointed attorney at no cost to you. Depending on your financial status, you may be required to pay a fee for the services of the court-appointed attorney. If you're going to hire your own attorney, you must make those arrangements soon. You must contact your court-appointed attorney prior to your trial date so they may be prepared to represent you. You have the right to a speedy and public trial within 60 days of today's date. The trial is held before a judge with no jury except for domestic violence charges, for which you may have a jury trial if you select a jury trial. You must file a timely demand for a jury trial. Under the United States Constitution, you are presumed to be innocent. At today's arraignment, you may enter one of three pleas: a plea of not guilty, a plea of guilty, or a plea of no contest. Nolo contendere is the Latin. A plea of guilty. If you plead guilty, you will be giving up or waiving the constitutional rights I've just explained. Your plea of guilty means that a misdemeanor conviction will go on your permanent record and the judge will impose sentence today, unless a pre-sentence investigation or an evaluation is required. The judge is required by state law to ask you if you've served in the United States military. You should not enter a plea of guilty because of any threat or promises made to you regarding the penalty. Only the judge can set the penalty, even if there has been a plea negotiation. A plea of no contest, or nolo contendere. You may also enter a plea of no contest, that the Latin is nolo contendere. If you do so, you will be giving up the rights that I've already explained to you. What it means is that you're pleading no contest. You're neither admitting or denying guilt. You are admitting that there are some factual basis to the charge and saying that you do not wish to contest the charges, and you understand that if there was a trial, the city attorney would be able to prove the charges or charge against you beyond a reasonable doubt. Once the judge has accepted your plea of guilty or no contest, he or she will then give you the opportunity to make a statement on your own behalf. A plea of not guilty. If you plead not guilty, you will be given a trial date before you leave here today. On your trial date, you and your attorney, if you have one, must be prepared to go to trial. This means that you must have your witnesses and evidence ready at the trial. The city prosecutor must prove the charges against you beyond a reasonable doubt. They do that by presenting witnesses and evidence. Witnesses could include the police officer, crime lab personnel, crime victims, or the driver of another vehicle if you were involved in a traffic accident. Photographs and documents are also considered to be evidence. You will have the opportunity to cross-examine, which means ask questions of the witnesses. If you choose to testify, you will be subject to also cross-examination by the prosecutor. You also have a very important constitutional right at your trial not to be compelled to testify. This is the Fifth Amendment privilege against self-incrimination that you hear about in the movies and on TV. If you go to trial and you do not wish to testify, the judge cannot hold that fact against you in any way. If you choose to go to trial, you have the right to present witnesses and evidence on your own behalf. The prosecutor is not required to subpoena all witnesses possible, only those that are required to prove the charges against you. At your request, the court will issue subpoenas to which you require your witnesses to attend and testify on your own behalf. If you wish to use court subpoenas, you must go to the clerk's office well before the trial date to obtain these subpoenas. It will be your responsibility to have them served on your witnesses. A word of caution here. Self-representation is almost always unwise. You must understand that there are dangers or disadvantages to self-representation. If you represent yourself at trial, you might very well conduct a defense that does not help your case. Remember, too, that the city prosecutor will be a trained attorney who will have the advantage of skill, training, and ability. You have the right to represent yourself at trial, and many people do so successfully. The judge will hear the evidence, apply the law, and then make a decision. If you wish to talk to the prosecutor about your case prior to your trial date, you may contact the city attorney's office during regular business hours, or you will have a chance to discuss your case with the city attorney on the day of trial. You should also understand that you are not required to speak with the city attorney, but may do so in an attempt to settle your case. You are never allowed to call the judge to talk about your case. You may only speak to the judge in the courtroom. If there is a good reason that you are unable to go to trial on your trial date, you may request a continuance. This request can be made in person at the court clerk's office, online, by mail, or by fax. Requests for continuance by telephone will not be granted. The request must be received within 28 days before a scheduled hearing. You should also contact the city attorney and notify them of your request for a continuance. They will either agree to the continuance or oppose the continuance. There is no guarantee under any circumstance that a trial judge will grant you a continuance, so you must check back with the court clerk's office prior to your court date to see if your request has been granted. Please understand that if you cannot afford payment of a monetary fine, you may ask for community service or a payment plan. A payment plan or fine may also be converted to community service. All the conditions are your legal responsibility. Do not ignore your obligations. If you fail to appear for a court hearing, fail to pay an assessed fine, or fail to otherwise comply with a court order, a warrant may be issued for your arrest. The court may report your failure to pay assessed fines to the DMV and direct your license be suspended or remain suspended until your obligation is fulfilled. Lastly, if you are not a United States citizen, a conviction of a crime, even a misdemeanor, could have a negative effect on your immigration status. I would urge you to contact an immigration attorney before you enter a plea of guilty or no contest. Should you have any questions about anything I've spoken about here today, please ask the judge or your attorney before going forward. Thank you for your attention.